Welcome class. In this module, we are going to explore a very interesting facet of IP protection, which is the neighboring rights protection. So traditionally, there was a close identification of copyright protection with the individual creator, the romantic notion of the author. The romantic notion of the author led to copyright protection in traditional context for artistic, literary, musical, and dramatic works. It was felt, and I'm talking here about the time when the Berne Convention was uh, thought of, conceptualized. It was felt at that point that works which involved creative effort but was the product of a team work was not necessarily fitting well within the purview of copyright protection. So the traditional notion of the romantic author did not, to a large extent, gel with the way some of these works such as phonograms, for instance, even performances, broadcasting rights, the way these works were created did not gel with the idea of the romantic author. These works were largely the product of team effort. And it is for this reason that you do not find mention of these works in the Berne Convention, the most important and pioneering effort in the field of copyright law as far as international treaties go. In this module, we are going to explore the nuances of protection of performances and broadcasting rights. These are considered the neighboring rights in the Indian copyright law framework. We do not look at phonograms here because sound recordings are covered within traditional copyright protection in India, and they are a category of works expressly mentioned in the Copyright Act post 1983. That is when the act was amended the first time, and sound recordings were recognized as an express category of works entitled to copyright protection. But as far as neighboring rights are concerned, the two categories of such rights in Indian law are broadcasting rights and performance rights. And these are the ones we are going to explore in the course of this lecture. Coming back to the international framework, because this framework is important to understand where globally India stands in terms of recognition of neighboring rights. As I already mentioned, the Berne Convention did not recognize these categories of rights or categories of works for protection under copyright. It took some time, a fair bit of time in fact, before the first treaty internationally to recognize protection for phonograms, performances, and broadcasters came about, and this was the Rome Convention in 1961. The Rome Convention took a minimalist view of protection for these neighboring rights, but indeed it granted protection. When saying that they granted or envisaged a minimalist protection, all that I mean to say here is that it was much narrower than the extent of protection as we see today in Indian law, or even as recognized by international treaties that came about later. So what exactly did the Rome Convention do? The first thing it did was to define a performer. Article 3A of the Rome Convention defined a performer as an actor, singer, musician, dancer, or any other person who acted, sang, delivered, declaimed, played in, or otherwise performed a literary or artistic work. Now, once you are recognized as a performer, or you qualified as a performer, and you created a performance, what was the scope of protection? For this, we have to turn to Article 7 of the Rome Convention. There are three broad rights conferred by Article 7 on the performance or on the performer in respect of that performance. These rights were: 1. The right against the unauthorized fixation of the performance; 2. The right against any unauthorized reproduction of any authorized fixation; and 3. The right against the communication to the public of such performance in an unauthorized fashion. So in all these cases, that is whether it was communication of the performance to the public, fixation of that performance in any particular medium, or reproduction of an already fixated performance, permission had to be taken from the performer, because the exclusive right vested in respect of any of these acts with the performer. However, and this is what makes the protection a minimalist one, as I had already mentioned before, there was a huge restriction on the scope of this right. This restriction arose in turn by way of Article 19 of the Rome Convention, which provided that once the performer had consented to the incorporation of that performance as part of a cinematograph film, he could no longer claim in respect of that performance any of the rights mentioned in Article 7. That's the rights that we have already discussed, three important rights of subsequent reproduction, fixation, or communication to the public. So from this position in the Rome Convention, one could surmise that the idea was not so much to grant absolute autonomy to the performer in respect of any use of that performance, but a conceptualization of the performance right as a form of monetization right. So the performer could make some money out of the performance by refusing to consent with the incorporation of that performance and exercising any of the rights, or getting some revenue out of consenting to the incorporation of that performance. But once he made that money, he could no longer say that the person who had incorporated it in the film could not reproduce it or could not communicate it to the public. So this was in a sense a binary on-off kind of situation, where either you consent to the incorporation and you lose your rights, or you exercise your rights but without consenting to that incorporation as part of a film. The moment you consented to the incorporation as part of a film, then the person who owned the rights in respect of that film would get to decide whether the performance must be reproduced, how many times, to which audience, and so on and so forth. This minimalist view of performance rights, however, came to an end in 1996 when the WIPO Convention on Protection of Phonograms and Performances, the WIPO Treaty on Protection of Phonograms and Performances, came into effect. Apart from extending the scope of performance rights duration to 50 years, this treaty did away with the minimalist conception wherein once you had consented to the incorporation of the cinematograph of the performance as part of a visual or audio-visual work, you would lose any further control over how that particular performance could be put to use. Doing away with that, the treaty provided for various important rights, such as the exclusive right of distribution to the public of the original and copies of the performances fixed in phonograms through sale or any other transfer of ownership or through commercial rental, and the right to a single equitable remuneration along with the producer of the phonogram for the direct or indirect use of phonogram of the performances which were published for commercial purposes, for broadcasting, or for any communication to the public. In other words, the treaty clearly thus does away with the fact that once it is consented for incorporation as part of a visual or audio-visual work, the performer would no longer have any further rights, and provides for a distribution of royalty between the performer and the producer of the phonogram itself. In addition, the treaty also recognized moral rights protection. The two important rights of integrity and paternity were carved out and conferred to the performer. Therefore, the performer could now insist, one, that he would be given the credit for any performance made by him, and two, that no such performance would be distorted or mutilated in a manner that affected the credibility of the performer or caused injury to his reputation. Acknowledging the growth of digital media and the power of technology to protect works, the treaty also allows the performer to resort to self-help measures such as technological protection measures and electronic rights management information, and performers can employ these in order to prevent the infringement of their rights. The treaty is also not entirely maximalist in the sense that it has allowed member countries to extend any fair use limitations that they would have already got in respect of the exercise of copyright to the exercise of performers' rights as well. Nothing new has been added to this framework by the TRIPS, though of course the WPPT in fact comes post TRIPS, but the TRIPS does not in any case add anything much to the Rome Convention, so it is something that one need not really look into much if examining performers' rights and its scope. So currently the position internationally is simply this, that if you consent to the incorporation of your performance in a film, you still have rights in respect of your performance insofar as reproduction of that fixation is concerned, insofar as communication is concerned, and you definitely have an equitable right to receive royalty, even if not a right to block the owner of the phonogram from making these important decisions on subsequent use of that phonogram which incorporates the performance. Having mapped out the international position relating to protection of performances, we can now turn to the Indian law and the provisions in the Copyright Act which deal with performers' rights.